And we are live.
Super. Would you call the meeting?
Sure. Let me just close this real quick. Good morning, calling the Board of Ethics Committee to order at 9:06 a.m. on December 22nd. To call the roll. Mr. Yusi?
Yes, good morning. I'd like to call the meeting to order.
Oh, I'm sorry, I'm calling the roll right now. Just say here.
Here.
Mr. Anand,
Yeah, here.
Mr. Armstrong,
Here.
Mr. Bishop. Mr. McEnany,
Here.
Ms. Palmer. Here. Mr. Ross.
Here.
Mr. Dion.
Here.
You want to turn it over now?
Yep, we do have a quorum,
Yes.
so. Based on the resolution that was passed by the Board of Supervisors, the first named individual was Robert Busi. So we're going to, he'll be the acting temporary chair for today's meeting. Thank you for accepting that position.
You're welcome.
If I may, on behalf of the acting chair, I did want to open it up to public comment. I did not place that on the agenda. I know there are some supervisors and our county administrator who may want to make a few statements or comment before we actually proceed with the meeting, and I wanted to give them that opportunity. If the chair of the board would like to make any comments to the Board of Ethics, I apologize if I wasn't speaking into the microphone.
Should be used to. But no, I'd just like to welcome everybody. It's an important role you play for the county, and we take this committee seriously. We take every complaint or non-complaint seriously, and I wish you the best in the next year. I know we're a little backed up because we had stuff in when the committee wasn't constituted properly, so you have some work to do, but welcome to Warren County. Thank you.
Thank you.
Supervisor Merlino?
I'm Supervisor Molina, Town of Lake Lucerne. I just want to welcome everybody here. This is an important committee, and I'm one of those guys that really respect it highly. And I hope we come up with a group of laws and regulations of how we're going to handle this. And I'm only speaking for myself personally. I was involved in an ethics thing at the beginning of the year, and I've been supervisor for 17. We're going to be 18 years, so my 18th year next week. And I just felt the way it was handled was improper, and I feel that even a criminal that killed somebody has a right in court to speak his piece or her piece and not to be notified. And I just want to know if we're going to have a chance that somebody files an ethics against me again. Do I have the right to know what's happening? Do I have the right to be maybe sitting there when the person that's filing it speaks to all the board? Because, sometimes we can have our right to speak and not use some people use this committee. And it's not all, even in read the paper today, even states having a problem with ethics board. Has their own personal way to go after people that they don't want. I feel that should be kept in the back of everybody's head. Straight laced. And I just wish you a lot of luck. And I hope I have to come. I never have to come see you, but it's important to me. I take it personal sometimes, and it's good that you have your piece to say. That's all I'm saying. Thank you all for being on it, because it's going to be a tough job, I think.
Thank you very much. Seeing there's no other public comment, I'll close the public comment on behalf of the board. Welcome, congratulations, and thank you. I guess that might be the best way to start. My name is Larry Ellman. I'm the county attorney for Warren County. In that role, I'm designated to serve as the legal advisor for the Board of Ethics. Practically speaking, we also try to serve an administrative role between the staff of my office to support the Board of Ethics, handling, scheduling, notifications, distributing information that needs to be distributed. My hope and goal for today, as you can see from the agenda, is to try to make sure we have everybody on the same page. So As you've already heard in public comment, the work that the Board of Ethics does is tremendously important. It can have a true and substantial impact on government operations in and throughout Warren County. So what I'd like to do is the composition of the board is different than it was earlier this year. And what I mean by that is we have less members who are considered public officers or employees. The board is more heavily weighted. This board, and now that everybody has signed their, well, 7 of the 8 members have signed their oath of office, is heavily skewed toward members of the general public, which is what's required by state law and state statute. So even though I know some members have served on the board previously or maybe have served in other capacities in government, I wanted to try to take an hour today to lay out somewhat of a foundation on which hopefully we can move forward together on. And my goal is really to focus on first the open meetings law, the reason that we're all have cameras in front of us and our pictures on the screen, and why this is being broadcast and open to the public. And understanding nobody has to be an expert on it. I'm probably not an expert on it at this point either. But as issues come up and issues arise, my office will research and develop answers that we need to help this board function as efficiently and thoughtfully as it can. The second is to focus on Article 18 of the General Municipal Law. So there's a whole bunch of state statutes. And one portion of those state statutes lay out some basic concepts and requirements for municipal officers, employees in the area of ethics. So I would like to try to touch on that this morning. And it kind of follows the article that I distributed and that was also posted, which comes from the comptroller's office. It can be a little heavy. You don't have to feel like it's a subject matter you necessarily have to master today or this week. But again, as we move forward, I think a large number of the topics that are addressed in that article, you'll see are also covered by the Code of Ethics in Warren County and will be involved with the different matters that you touch as appointed officers to the Board of Ethics. So unless there's any initial questions, I'll probably just continue talking unless there's some maybe administrative questions, concerns I can answer. And hopefully by the end of today, everyone here will have a better sense of what they've actually just signed up to participate in. And if we do that, then I feel it's been a very productive period of time together. So I do want to start with open meetings law. One set of statutes in New York State is called the Public Officers Law. And the Public Officers Law touches a lot of different areas. There's 2 articles in there that may involve or may touch on operations here at the Board of Ethics. First and foremost is Article 7, which is the open meetings law. I just kind of want to talk through it a little bit so everyone has an understanding of why we're here on the record in open session. So under open meetings law, a meeting is any official convening of a public body for the purpose of conducting public business. So this board has been appointed by the Board of Supervisors for Warren County. You'll also see that it's a public body as well, as that's defined by open meetings law, meaning it's a group of individuals, 2 or more, where a quorum is required. And I'll discuss quorum in a moment in order to conduct any business. So the first thing we did today is the clerk of the board did a roll call to determine how many members were here. In large part, that's required to make sure we have a quorum. meaning we have more than half the membership present in order to conduct business. So today, and let's talk a little bit about the different positions that people have been assigned to, that there are 5 primary members of the board, and there are 3 alternates on the board. An alternate will be able to fill in for a primary member when a primary member is not attending or unable to attend and participate. Many boards, you just have your primary members, which in this case would be 5. And in order to have a quorum, you need 3. So my hope is with 3 alternates, there hopefully will never be an occasion where we schedule a meeting where we can't conduct business, because we'll have at least 3 members, if not a full slate of 5. And it's those primary members that are the voting members for that meeting. So if all 5 primary members are here and present, they're the 5 members who participate in the discussions, the deliberations, if necessary, and the voting on what action, if any, to take. An alternate, when they fill in for a primary member, will serve that same role for that meeting as the primary member who's not in attendance. There's also an additional wrinkle under the ethics laws because it distinguishes between our public officer and employee members as well as our members of the general public. So we have 1 primary member who's a public officer and employee, and 1 member who's an alternate in that same position as public officer, as a public officer or employee appointed to the board. So that's generally the construction of the bodies of who's here. Everything that's done by the board is done in public session. That's required by the code of ethics that was passed by Warren County that created this current structure. The exception is there's some areas and some topics where the board may, they don't have to, but they may take a vote to go into executive session. And an executive session is a period of time where the board agrees that for that one particular topic, or specifically a number of topics that were identified, they're permitted under state law to go off the record, to exclude members of the public, to literally physically close the door in order to engage in discussions on that one particular topic. There's a number of different reasons under state law where a board can go into this executive session. The one that I think is most likely to be used, and the one that's most I suspect important for the board to use, is under section 105. And there's 2 parts to it. First part is that if the board is having a discussion regarding a medical, financial, credit, or employment history of a particular person or corporation, that may apply, but I think the second part is the one that may be more prevalent. When there's matters that are being discussed that would be leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. And it's really those, at the end of that sentence, after the word promotion, which was demotion, discipline, suspension, dismissal, or removal of a particular person or corporation, which may trigger the desire of the board to have a discussion, not in public, but behind closed doors regarding that particular person or corporation. Now, with that said, I do want to make sure that the board understands under the code of ethics that Warren County passed is that this board cannot vote to actually take any of those actions. You can only make a recommendation that would then go to the Board of Supervisors recommending that they take that action, or potentially to a department head, that the department head take that action. But the action that this board takes, the deliberations and the final determination that you make is only of an advisory nature, meaning it's a recommendation that you make that may or may not be followed. Our meetings have to occur in a physical location like here. We're not authorized to have members participate through Zoom, through video conference currently. That may or may not change in the future. This room is open to being photographed, and members of the media can come in here. The proceedings are recorded, but they can also be recorded while the proceedings are occurring. We also provide the public prior notice of any meeting, especially if the meeting is scheduled more than 7 days into the future. So if we were at the end of today to schedule a meeting into January, we are required to make sure we publish a public notice that the meeting is going to occur at least 3 days or 72 hours before the meeting starts. If the meeting is scheduled quicker than that, then we try to get the notice out as soon as possible, but not less than 24 hours, generally speaking. And then for an executive session, the one thing I did not mention is you can have any person who's not on the Board of Ethics remain in for the deliberations. So it's not really like a jury in a criminal trial where they go back there and they're sequestered. But you could have, and I would strongly encourage that the clerk of the board or the clerk's representative attend any executive session. That someone from the county attorney's office be present to provide legal advice. And then any other person that the board includes in that motion that they want to have present in the executive session can remain. There's one exception to the open meetings law. And it's the shorthand is basically attorney-client communications. So if there comes a moment or a time where there's a question that the board poses to my office, and it's of the nature where it's going to be legal advice that I'm providing to the board, I will strongly encourage the board to go into executive session to receive that advice as the client for the county attorney and the county attorney's office. That's a lot of information. Some of it might sound familiar. I know some members of the board have been living under those rules for a while. Is there any questions that I can answer, maybe clarify? Basically, what we do is going to be in public session unless there's a valid basis to go into executive session and someone on the board makes the motion to go into executive session and it's passed by a vote, by a majority vote. Okay. So I'm going to dig in a little bit on Article 18 of the General Municipal Law, which is to some degree mirroring the article that I provided you, which can serve as a resource going forward. And Article 18 really does two things. One, it provides consistent rules for ethics that apply across the state of New York. The second thing it does is it gives the local municipalities, to include counties and specifically Warren County, the right and the ability to make additions to those statewide rules and to even potentially tighten up some of those statewide rules if the county feels it's appropriate. So it provides a certain amount of discretion and ability for the local municipalities to look at the statewide rules and then fashion them to work for their community and their constituents and their government. There's a couple of main areas under the statewide rules that are addressed, 6 in total. The first one, which is probably at least by commentary that I read, the one of the most important ones is addresses the question of when a municipal officer or an employee may conduct business with that same municipality. So putting that in terms of Warren County, when can a officer or employee of Warren County conduct business with Warren County? And what does that mean? We'll take a little time this morning to just kind of flesh that out a little bit to hopefully give you a little kind of a mental construct of how to think about that. Another area addresses solicitation and accepting of gifts by municipal officers and employees. Third area is disclosure and use of confidential information by municipal officers and employees. Receiving compensation for services is another area. There's some limited aspects of land use that I'm not going to really get into today because it's a pretty small area. And then the last area, which we will talk about, is the annual financial disclosure requirement that's put in place by New York State ethics laws. So these rules, these statewide ethics rules in Article 18 apply to all municipal officers and employees. And it applies to all municipal officers, whether they're paid or unpaid. So I did once again want to congratulate each of you now that you've signed your oath of office, because each of you, whether you're paid or unpaid in your capacity as a appointed official or officer to this board, is now subject to New York State's Article 18. Welcome to the family, guys. So with that said, I want to start with that most broad area. And maybe under the ethics rules, what many commentators consider to be the most important, which is prohibited interests in contracts. When does a municipal officer or employee have what's considered a prohibited interest in a contract? And there's really four parts to it. I'm going to give you like just four, maybe five little buzzwords to think about, because it's kind of these are the factors that you work through. First and foremost, in order to have a prohibited interest in a contract, you have to have a contract. And in New York State, a contract is very broadly defined. It's not just limited to a written document signed by two individuals. The second is that municipal officer or employee must have an interest. And we'll focus a little bit on what that means to have an interest in a contract. And then third would be powers and duties. Powers and duties. And the question is whether that municipal officer or employee must, in their official capacity, have one or more of the powers or duties that can create that prohibited interest. Meaning, the powers and duties of the officer, does it give them the ability or power, not that they use it, but just the ability and the power to be involved in certain ways with the creation of that contract interest? When you hit those three, is there a contract? Is there an interest? And what are the powers and duties of the officer or employee connected to that contract? You're through the main part of the analysis to determine whether or not that's prohibited under New York State ethics laws. And then once you hit that point, there's a series, I believe there were 16 exceptions that the state provides of how that public officer or employee can still move forward without being in an ethical conflict, despite meeting those three requirements of there being a contract, the officer or employee having an interest in it, and the officer or employee having some powers and or duties relating to that contract area. So as I said, digging in a little bit more into the contract, it really can be just about anything. It's a claim, an account, any demand against the municipality. It doesn't have to be in writing. It can even be implied. Basically, any business relationship with the county would qualify as a contract with the county of Warren. An interest in the contract, that's the part where the work really comes into play, because in order to determine an interest, it's a very detailed factual analysis, and the board would determine based on basically collecting up as much factual information as you possibly can about the circumstances surrounding this, what the facts say about whether or not there is a direct or an indirect pecuniary or material interest in the contract. One of the examples that I've seen, and this was an actual case in New York State, gave the examples of a municipal officer or employee, I don't know which category he was in, who basically had a roommate, somebody he was not married to, someone who was not his or her spouse, and they shared expenses for the place where they lived. That roommate entered into a contract with the same municipality that the roommate worked for. And the court determined that the municipal officer and employee, in fact, did have an interest in the contract, because the roommate, we'll call him roommate two, or the non-government employee roommate, had a contract with the municipality and got money from it. And he was using that he or she was using that money to help pay the joint and shared expenses for the apartment, which created an interest on behalf of the government employee. So this can sometimes, in New York State law, sound pretty attenuated, kind of out there. It's not necessarily, trying to think of a first name of someone who's not on the board, Joe. May not be as simple as Joe working for a municipality and then having a signed written contract with the same municipality. So the nuance that's in there can cover a pretty broad range, and that's why that factual collection of facts and understanding of what the facts are can be so important to trying to get to what the right answer is under the ethics laws. There are two areas of presumptions when it comes to these interests. So we're really on that second factor, right? We talked about contracts. We're talking about interests now. And there's presumptions based on a relationship. And if these relationships exist, you don't need to really go into the factual basis, because the law presumes there's an interest. There's three categories: a spouse, a minor child, or a dependent. So if the government officer and the employee's spouse, minor child, which I really don't get or understand for legal reasons, because minor children often don't have the ability to contract, or a dependent, has something that's a contract, something that is equal to, under the law for ethics of a contract with the same municipality, in this case Warren County, the interest is presumed to exist. And the same is true for certain business relationships. When a municipal officer or employee is a member of a business entity, corporation, LLC, partnership, or an employee, or even sometimes in some circumstances, owning stock in a corporation, that can trigger the presumption that he or she automatically has an interest in the contract.
Mr. Hillman, those relationships also include stepchildren, is that correct?
Under Article 18, I do not believe it does. Under the Code of Ethics for Warren County, I do know it's clearly defined as stepchildren. So I'd have to go back and look at the statute on Article 18. But I don't know that stepchildren are specifically referenced in the state statute. What's clear though, and what's required under the state Article 18 as well as our code is disclosure. And it's really disclosing all of those interests, all of those potential interests. And as you'll see, as you venture into your first financial disclosure statement as officers for Warren County, the focus is really having the officers and employees fully disclose all of the potential areas where there may be a conflict with Warren County under these ethics rules. Which is also a requirement under state law and under our local code. So then you move on to that third and final. So we have contract covered. We talked about having an interest in the contract. And it's the powers and duties with respect to the contract. You know, does that officer or employee negotiate, prepare, authorize, or approve the contract? Do they audit the bills or the claims that come in? Or do they have the ability to appoint an officer or employee who exercises any of those specific powers? We're not just talking about like a ministerial role, like maybe somebody who prints a check for a contract, but somebody who's involved really in that core function of either creating it, authorizing it, or approving payments under it as that contract relationship goes forward. And it just came into my mind, and I often try not to speak extemporaneously, but it kind of hits me how there's kind of a hierarchy in Warren County where the higher up your position is, the more of those you touch, and the more clear it is that your powers and duties cover many of those different areas. So the Board of Supervisors is really the governing body for Warren County. And while they may not directly negotiate or prepare, they do authorize the contracts. And in some situations, they may approve payments depending on the contract. And as you move down through Warren County to department head levels, then you'll start to see, you know, they don't have the authority necessarily to authorize the contract, but they may negotiate or recommend an approval for that contract. And then as you move farther down that chain, you start to move farther away from the types of positions that would have powers or duties, or the ability to exercise powers or duties that would impact that contract. So the core concern, and the reason we went through those steps, those 3 steps, is really to identify when there's that prohibited interest, meaning all 3 of those factors line up in a way. Not that the officer or employee is actually going to use his authority. It's merely the fact that it exists, meaning that they could use their authority. So if they're granted the authority and the power, that's the core question, not did they use it or did they not choose to use it in a certain circumstance. What seems to be very clear under Article 18 is once you've defined and that each of those 3 steps apply, and you do have a prohibited interest in a contract, you can't cure that by merely recusing yourself or abstaining from taking action on that particular piece, because the prohibited interest exists. And once you have that prohibitive interest, then the last step is then running through the statutory factors to determine whether or not there's any exceptions. And I'm not going to go through all 17. I don't want anybody on their first day to throw anything at me, so I'll just hit kind of the highlight reel. Before I go through that, are there any questions of a general nature or anything you want me to go back and repeat concerning those 3 steps when we're looking at conflicts of interest relating to a contract interest? And that's, is there a contract? What's the interest and what are the powers and duties? Excellent. So some of the main statutory exceptions. Well, first, let me start with what's not an exception. There's a requirement under New York state law that many contracts be competitively bid, meaning that there's a bidding process, an open bidding process, a solicitation of bids, and a procedure that follows. None of these statutory exceptions can apply on a contract that's competitively bid. So one that goes out to bid, we get the bids back, we open them up based on usually low bid or whatever other factors may apply in certain circumstances. Competitively bid contracts just simply are not permitted to be found as an exception to the prohibited interest rule. Pre-existing contracts is an exception. So for example, if there was a member of this board who had a contract or has a contract that's in place with Warren County, you would need to disclose that as part of your financial disclosure, but there is an exception under state law for a pre-existing contract. Now, the renewal of that contract would be a problem going forward. And I'm just using this, of course, as an example. But the existence of it on the day that you started doesn't create the conflict under state law. One of the larger ones is not-for-profits. So many officers and employees of a municipality also serve in various roles with not-for-profit corporations and entities. And not-for-profit corporations have a very wide exception. So if there's a contract with a not-for-profit and you're hitting those elements of it's a contract, there's an interest, and powers and duties relating to the contract are exercised by that officer, the exception is if it's a not-for-profit, it just doesn't apply. The other one, just to kind of throw it out there, is municipal agreements. None of this covers an agreement between one municipality and another. So in Warren County, you'll often see intermunicipal agreements potentially with towns. And there is nothing in that form of a contract that's covered by Article 18. It's just outside the scope of what they consider a situation where a conflict of interest can arise underneath these ethics rules. So why do we care about all of that stuff? The primary reason is because we have to, because New York State says the County of Warren has to care. I think the more truthful and honest answer is the hope is in creating these statewide rules and giving local municipalities the right and the ability to formulate these rules and additional rules that will work well for them, that we're creating a level playing field, we're encouraging open and honest disclosure early, and aiding and assisting in identifying potential conflicts before they become actual conflicts. And I guess in some part, and we'll talk about in a moment, the different job duties that's been assigned to this board, one of which is dealing with circumstances which may be ambiguous or unclear, or when it just wasn't disclosed. So my hope is always that your amount of work in that area will be approaching zero. with the reality that it may not be. But that's why these rules are important, having some construct and framework in your mind that you can work with as you start to see and hear and are presented with some of these issues, I think will be helpful. And of course, additional legal counsel or attorney-client communications can be available to address and assist and aid in clearer understandings, because it's going to vary very differently in every single case. Any questions on that very general, very broad coverage on Article 18? Excellent. I'm going to move very quickly through the rest because I am going to do my best to stop talking at 10 as promised when we scheduled this. So our local law 2 of 2022 is what created this new structure. It largely it did leave completely unchanged all other aspects of the code that were in effect for the previous board. The only tweak that's changed is that all of these meetings are now required to be done under open meetings law. So therefore, and we've already talked about the fact that whatever action you do take is only advisory in nature, which doesn't minimize the importance of it, because the time, energy, effort, thought, and dedication that you put into any particular topic that comes before you is going to be reflected by that work product and that recommendation that then's provided either to an individual employee, as we'll see in some cases, to the Board of Supervisors in other cases, or to make a determination and recommendation regarding a potential violation of the rules. There are 4 main assigned responsibilities for the Warren County Board of Ethics. First and foremost is in the field of financial disclosure. There's a very specific list of individuals in Warren County who must file annual financial disclosure statements. They are filed for safekeeping purposes only with the county attorney's office. The county attorney's office does nothing with them other than organize them and ensure that we have a running list of who's filed them. The work on those comes from the Board of Ethics, and it's part of the obligation of the board on an annual basis to review those filings to identify any potential issues or concerns. I guess primarily first to make sure that they're filed, second, that they're fully responded to, and then third, to ensure that there's nothing that would potentially be a issue or concern that needs to be addressed on the face of the document. The second is the authority to issue advisory opinions. So the board has the ability to issue an advisory ethics opinion when one is requested of the board. In providing that advisory opinion, it should be in writing, is my recommendation. It becomes part of the history of the board and their decisions. And it also provides a safe harbor to the employee or officer who receives it, so long as they follow the recommendations that are provided by that advisory opinion. Third is on an annual basis, the Board of Ethics is asked to review and make recommendations for modifications or updates to the code. Things that in your operations you see that may not be working as efficiently or clearly as they could. And then the fourth and final is really receiving, reviewing, and taking action on sworn written complaints. And sworn written complaints are complaints that can come from any source, officer, employee of this municipality, of other municipalities, or members of the general public. Determining if, and then coming up with a process to address and resolve any allegations in those sworn complaints. So that's the core of the responsibilities. The code also addresses the annual training program. Every officer and employee of the county is required to complete annual ethics training, which will occur this January. We already talked about the annual statement of financial disclosure. And then under F on the agenda is discussion of potential rules of the Board of Ethics. What I'd like to recommend is, if it's acceptable to the board, there was a set of rules that were passed by the prior board. I would like to go through them, amend them so they reflect the new structure and the fact that the meetings will all be open meetings. And prior to the next scheduled board meeting, we will distribute and publish them so members of the public can see them as well. And hopefully that'll give each member a time to review them, to think about them, and then to engage in a conversation of, do they work? Are there areas that you don't like, you do like, so that we can come to a final script? There's no clear procedural guidance given to this board by the Board of Supervisors through the Code of Ethics. So these rules that I'm talking about would be proposed rules that this board would consider and then adopt, which would then guide you in how to dealing with each of these 4 core responsibilities. Any questions I can answer on any of the topics that I've discussed? Because I am pretty close to G and H right now. There's
Gentlemen, just a clarification, I may have taken a little nap during this discussion when you talked about executive sessions. We're under the auspices of open meetings law. Our executive session also under that requirement to be publicly.
That's a great question, Mr. Ost. And one of the reasons I wanted to go through and start with that statute today is to try to help everyone be on the same page with it. So this thing that we call the executive session is kind of what it sounds like, meaning it's a session that's done off the record. The cameras go off, the doors get closed, and only the people other than the board members that the board wants in that session are in the session for the discussion. But it has to be clearly related to one of the exceptions. And again, the core exception is a matter that would lead to demotion, discipline, suspension, dismissal of an employee or a corporation. And I keep saying both employee and corporation. Because that's what the statute says, and it's possible that there might be a corporate entity at some point involved in a proceeding before the board. It doesn't necessarily have to just be an individual, but it could involve a corporation where an individual is an employee or an officer as well. So does that help kind of clarify? Everything other than that executive session is on the public record, in the public domain, and open for public view.
Yeah, that clarified that. Thank you very much.
And again, it doesn't mean that this board has to vote to go into public session. I'm sorry, executive session. But there may be certain circumstances where the topic is going to be of such a nature where you do want it to be limited. And while this board is trying to determine what steps, if any, to take. So I put down on the agenda for the next meeting, the election of a chair and a vice chair, the review and action on the proposed rules for the board, and if we have time, to start a reviewing process for some of the filed sworn complaints that have come in over the last 6 months. I'm just kind of, this isn't a vote, but looking for a consensus if that sounds okay to everybody. there's anything maybe you would like to have addressed at that next meeting, let us know. And my hope is at the next meeting, we could start by electing who will be the chairperson and the vice chair. And then they will coordinate with my office in putting together agendas as well as meetings in the future. So that takes us to maybe that next to last question of when would you guys like to meet again? And I would like to ask that the members consider the week of January 9th as a potential week. I'm not sure if there's potentially committee meetings that may occur that week, or we just don't know.
We shouldn't have any committee meetings till after the January 20th board meeting. So
Okay.
that should be clear for us.
What date was it, Larry?
I'm looking at any day the week of January 9th. So January 9th, which is Monday, Tuesday, Wednesday. Well, Wednesday wouldn't work for me. Monday and Tuesday all day. And going forward, we won't do this in a public meeting. We'll do this, we'll get a schedule together. And if we can make regularly scheduled meetings, I think we have enough work to do that for the next few months. But to get us off and running, is there anyone who would not be available on either Monday, the 9th or Tuesday, the 10th?
I'm good.
Okay.
Good with me.
And does this 9 o'clock time work for everybody, or is there a better time of day?
Sorry, getting over. I'm not available on Tuesday, the 10th at 9, but I could do Monday.
Okay, let's go Monday at 9.
Is it possible to go later? We do a team meeting for our business Monday mornings from 8 to 9.
Yes, can we go 11 o'clock? I know the 8th member will be available at 11 o'clock on Monday.
How long do we anticipate?
I leave that up to you guys. I don't want to, I would like to try to keep this next meeting to an hour again. At some point, that may not become practical. Given when we get into issues, sometimes you need to stick to it until you can resolve it, if you can. But I think an hour to work out who's in charge, what the rules are, and to maybe start looking at some of the earliest complaints, or the oldest, I should say, complaints that have been pending would be a pretty good day. So if it's okay with the acting temporary chair, we can schedule the meeting for 11 a.m. Monday, January 9th, 2023.
That's fine. Thank you.
2023.
Any public comment? Seeing none? Any privilege of the floor, which means that any member can make any statements or comments that they wish if they choose. They don't have to.
How often will we be meeting, or should we be meeting?
I don't know. I think right now there's two things that bluntly, there's two factors. One is January, February, March is a busy time of year for the Board of Ethics because the annual financial disclosure forms are coming in through to the end of January. So starting that review in February and follow-ups in March can take some time. Layered on that, there are more than a handful of complaints that are requiring attention from the board to determine what, if any, steps to take with them. So I don't know how the board will work together, how efficiently it will be, or how much time and deliberation the board wants to take on each individual matter. So it wouldn't be fair for me to say. I would honestly, I would love to be able to have 3 meetings in January to try to get through all those complaints. But I also respect and understand that almost all of you are, well, nobody is being paid for being a member of this board. So I appreciate your time and the fact that you're volunteering, and everybody has full-time jobs or other pursuits outside of the Warren County Board of Ethics, which is a very good thing. So that's my long answer to your very short question. Okay.
Yes, Mr. Elman, would there be opportunities to view disclosure statements or other documents through electronic communications to us so that we can do that between meetings? So
We can discuss that at the next meeting. There's some sensitivity and concern with the handling of those. In the past, we used the process of basically putting together work binders, which may not have been the most efficient way to do it, but it at least kept physical control over all of the disclosures, which will also include all of your disclosures and my disclosure and other people's disclosures from Warren County. So it's not my place to really say yes or no, just to try to guide or advise you on some of the concerns that I'm aware of on that one particular issue. But I think that's a great question. That's a great question. How do we do that efficiently?
there may be some technology that could be employed to ensure that those are locked documents and so on, but I'm not that familiar with that.
If the chair would like to see if there's a motion to adjourn.
I would propose a motion to adjourn.
So on a motion, what will happen is someone other than the chair would make a motion. That motion would be seconded if it's agreed with, and then at that point, there would be a discussion if there's any. And then at the close of discussion, there would be a formal vote on whether that motion passes or not. So, okay.
Is there any discussion?
Seeing no discussion, all in favor?
Aye.
Opposed? Thank you, everybody.